a tremendous partner with the trust in helping our law enforcement community stay out of trouble and defend us when we have a situation where we may have a claim. And so we appreciate her taking the time to put together a tremendous presentation. I reviewed it. It's great material, and just like the rest of you out there, I'm saying it's time for Jason to be quiet and allow Heather to talk. I'll throw the ball over there, Heather. A little window will pop up and ask you if you want to be the presenter. There you go. Perfect. And from that point, you can just pull up your PowerPoint presentation.
All right, I think we're ready to go. Thank you so much for being here today. Thank you for allowing me the opportunity to work with all of you. I consider it really a privilege and an honor to be able to work with law enforcement in the state of Utah. I so look up to and admire our police officers and our and the administrations that help them throughout this state. You do a great job, and I know that it's a difficult climate out there right now. There isn't a morning that goes by that I don't go to the gym and first thing there is something new officer related, and it's a tough climate right now, and but I think we're going to get through it, and I think we're going to be able to help educate the public on the good things that we do and change that perception. And so one of the things we're here to talk about today are things that we can do, things we've learned about in the past to avoid those. So let's start a little bit with the law enforcement climate. Really, you can see as we've watched over the last year or so that police officers are really under attack throughout the country right now. And we need to look out for ways to be able to prevent things that we can and to respond to things that we cannot. Officers' actions are being heavily scrutinized in all areas, whether it's use of force, whether it is driving pursuits, and just general interactions. You know, here we are today doing this webinar, which is an amazing way that we can bring people together. One of the things that's great about technology, one of the things that it's a challenge for is that people want immediate answers. We carry these little computers in our pockets that also act as phones, and they want, you know, people are used to being able to press buttons and obtain immediate answers to things that they want. And so things are changing and they're different, and we're going to have to adjust to those changes. The access through technology to all this information really means that officers now are not only scrutinized and their actions reviewed in a court of law, but also in the court of public opinion. And you've seen as the media has jumped in on certain areas how we really have to get in and respond to those things. You know, the legislative session was very interesting. This last session, one of the major issues was body cameras and video recordings. You know, body cameras are not the only way that video or that the officer conduct is captured. We have video recordings everywhere. You know, there are body cameras, cell phone videos, and even commercial and residential surveillance. You know, when I was talking with Ken Wallentine about what to tell people, he said, tell the officers just to make sure to assume that they're being videoed. This was a couple of years ago, and I think that that's even more true now that officers are having body cameras. I think that's a really good thing. I think most officers are very looking forward to having those body cameras because they are helpful and they will show the good deeds and the difficult situations that we're in. But it's really important to remember that they are not a guarantee that things will happen. those reports that you write are so crucial because they capture things that cannot be captured on a camera. And so it's really important to not rely solely on video recordings, but to use them as one extra level of protection to help us. One of the things that's interesting is that the measuring stick for officer conduct remains the same, and that's the reasonableness standard of the Fourth Amendment. The thing that is changing, however, is that public perceptions and their expectations of what reasonableness is changing. And those are sort of the areas where we're going to have to learn from and make adjustments. If we don't do that, we'll suffer negative consequences, some of those including inability to obtain convictions in criminal cases. You know, and as we talked about the public trust, you know, as officers are more and more accountable in the public opinion, we need to ensure that we continue not only to maintain public trust, but that we grow and build it. And if we don't adapt in the ways that we should, that is going to be a problem. And then finally, there are monetary repercussions for the cities. And the monetary repercussions can not only apply to the cities, but they can apply to individual officers as well through punitive damages claims and law enforcement employment consequences. So those are the things, really the reasons that we need to make sure that we stay up on things and that we learn and that we adapt. So we talked about the employment issues. So what we want to do is to, as I said, learn from the past. And some of those things is, what did we do right? How did we address situations well? And then also what did we do wrong in a circumstance, but not even only necessarily what we did wrong, but how can we just improve? So maybe we did something right, but we want to improve upon that. So the purpose really of today is to address some of the issues that we're seeing in cases that we've handled through the state and issues that we've seen throughout the country. And what have we learned from those and what can we do better? So moving along to those issues, one of the issues that I have seen in cases that I've dealt with are those that relate to reasonable suspicion. It's just generally going over the basics of reasonable suspicion. To stop and detain someone, we must be able to demonstrate that a crime has occurred or is about to occur. Now that does not take into account the voluntary stops. Those are probably the largest set of stops that occurred, and the reasonable suspicion standard does not apply to those. But a lot of times, voluntary encounters will occur, and then the detainee will want to move along, and then it becomes, do we have reasonable suspicion to continue to detain this person despite the fact that they want to? And we need to ensure that we have not just a conclusion or a suspicion or a hunch, but there has to be articulable facts that a crime has occurred or about to occur. And it's really critical for our officers to include that information in their reports and not merely the conclusion that they felt that a crime had occurred or was about to occur. Specifics about what they observed and leading up to and occurring during that consensual encounter, interviews, those kinds of things. Now the next thing is, we're not seeing this as much, but I thought it would be helpful to bring it up, is when do you have the ability to frisk someone for reasonable suspicion? And the Supreme Court has confirmed that the officer needs to have a specific suspicion that the person being detained is armed and dangerous. So there must be articulated something about a bulge in a pocket, maybe the person's history, those kinds of things. It's just not enough, the area where the stop is taking place, the type of stop. those kinds of things to help explain. And what we're really doing in any context is really educating and explaining what we're doing in those reports. We're doing that to the criminal jury, we're doing that for the public, we're doing that for our supervisors, and we're doing that for a civil thing. And if we just really explain those things that are happening, that really goes a long way. I think the public in Utah is very still favorable for law enforcement officers. We want to keep it that way. And the way that we do that is to help them to understand what it is we're doing and why it is we're doing those. And if that sounds reasonable to them, they usually are very favorable for law enforcement. Now, reasonable suspicion, remember, is less than probable cause, but it has to be more than just a suspicion or a hunch. So we do have to articulate those specific factors that lead to the conclusion that someone may be dangerous and armed, or that a fact has occurred or is about to occur. And it can result from a combination of facts, even if each individual one does not sufficient on its own to give rise to that. So the more information you can include, the better chance you have of convincing a judge or a jury that there was reasonable suspicion. In articulating reasonable suspicions, again, as I mentioned, conclusions really are not sufficient. Things like, I feared for my safety, I believe the suspect had just robbed the store. Those are important, and you need to have those in there because it brings everything together. But we have to remember that less is not more in these situations. We want to articulate each supporting fact in the report, and those factors can include things like where the occurrence is taking place, what time of the day, is it night, middle of the early morning, or things are different at 2 or 3 o'clock in the morning than they are at noon on a Sunday afternoon. So include those types of things. Lighting can have an effect on things. An individual's reputation, what the reputation of a place is. Are you at a bar? Are you at a church? You have to paint this picture for people. Really crucial to it is what the person is acting like, and not just things that they're saying, but body language and tone of voice. Those are things that are crucial. And sometimes cameras will not capture really what that tone of voice is, even though you hear the recording. It doesn't capture the immediacy of the threat or the need, and that's why you want to explain those things in the police reports. And body language will often not be captured. Tightening of the muscles or certain movements may be in the way. We still have dash cameras, and you might be a body camera that you have on, you might be too close, interacting hands-on, and you still may have your dash camera rolling too, but you're between that. So why those articulation of these things are so important. The another thing is what the scene and the suspect look like. We all know that people clean up really well for court, and they do not look like the people that we encounter when they come into court. So really describing what they look like, what they're wearing, what does their T-shirt say, what their, again, back to their body language can help. Now, one other thing that is really important to remember is that reasonable suspicion only lasts as long as it is reasonable to confirm or dispel the suspicion. And that's where we're seeing some of our Utah Supreme Court and appeals court decisions come down, is that an officer had reasonable suspicion to continue a stop, but acted longer than was appropriate once they learned certain information. So if you're and we all know that that interviewing and investigating is building upon things. And so one of the ways that you can help do that if you have that reasonable suspicion enough is to continue, the how the person was acting, and continue to go along and show that there's this continuation as you're building on that reasonable suspicion. So those are the pointers that I wanted to bring up on reasonable suspicion. I want to really invite questions and comments if you have them, because this is an opportunity for us to learn from not just the cases that I've had, but from situations that you all have had as well, and there can be a good discussion about that. So please feel free to jump in and have those questions and comments. And if you don't, but you think of something later or would like to discuss it, please feel free to call me anytime at my firm or send me an email. I'm happy to talk with you about that.
So on that line, Heather, you talked about some court cases on reasonable suspicion. Is there an example of kind of where an officer went too far with reasonable suspicion?
One of the things that we're finding is traffic stops. We see those frequently, both in the state of Utah and in the federal courts in the 10th Circuit. And, you know, I had a case that was really interesting where an officer stopped an individual for a traffic violation. That's usually how it begins. And the person was acting suspiciously, but the officer had that officer hunch, that sixth sense, and knew something was wrong. But really there wasn't anything beyond that the officer could do. You know, it was in the middle of the day. There wasn't, and the 10th Circuit and the Utah Supreme Court have ruled that just acting nervous when interacting with a law enforcement officer is not sufficient. We all get nervous. I get nervous, and I work with you all and respect you. And so that's not enough. So what this officer did, and here are some of the magic words, is that you tell the person that it's over with and return. The other thing is you can't just keep their papers. You have to return them to them. And we've seen that repeatedly in 10th Circuit and Utah cases. So make sure that you return them and let them know that the traffic stop is over. And then after you have returned that, ask them if you might ask them some other questions. And you might be surprised at how often they would continue to cooperate. And we were able to get out on that case when the officer did that, included it in his report, and there was no objection by the plaintiff when we filed a motion to dismiss, and we were able to get dismissed out of the case and not even have to go through the discovery phase.
Great.
All right, moving along to witness detention. Oh, excuse me, let's move along to officer-involved shootings. We're seeing them more and more these days. We had one for one of our members just last week. They are being heavily scrutinized for several reasons. You know, there are possible criminal repercussions for the officer. The media has really taken a great interest in them. You know, in addition to the possible criminal repercussions for our officers, there is a possible effect on the officer's employment. So there are several issues that we want to look at that relate to a shooting that can be problematic. So let me just back up a little bit. We want to make sure that in these officer-involved shootings that we really focus on what it is that we need to do up front. It's so important up front that we are really setting the table for not only the criminal, and that is the criminal investigation is the most important part. And I say criminal investigation, it's not just the officer who's being criminally investigated. The officer is also considered a possible victim and is often determined to be a potential victim. And so we're setting the table for that criminal case that is to eventually be brought, whether it happens to be against the officer or against the suspect. But we're also relating to things that having an effect on what the officer's employment status will be, whether there's any disciplinary action, and then down the road to civil cases. Things that happen in these criminal cases, in these criminal investigations, really are admissible, and they're discoverable in civil rights cases. And so we want to be very careful up front to ensure that you involve counsel at the earliest possible phase. I've dealt with cases where I've ended up defending civil rights claims, and they've gone I'll never say any of them go completely smoothly, because they are difficult and they are lengthy and they are very emotionally taxing. But the ones where that I've been brought in very early on, we've been able to address issues up front and help prevent possible problems down the road. And so I would counsel you to get counsel involved at the earliest possible time to help walk through and deal with any pitfalls from that moment. All right, moving on to witness detention. This is a really tricky issue that we're seeing. Fortunately, plaintiff's counsel has not caught on to it a whole lot recently, and we've been able to get out on motions, but this is an excellent opportunity for us to learn and prevent something from happening before a verdict or constitutional violation is found. It's crucial to remember that the Fourth Amendment applies to witnesses, to a shooting, to a takedown, to a pursuit, to any type of interaction with an officer. And so we're governed by that standard, which is the reasonableness requirement. There was a case years and years ago that I assisted in trying that where a shooting occurred at a family's home, and the family was out on the porch, and the mother and sister of the man who was shot were watching when it happened. And immediately following the shooting, officers, as they should have, detained the witnesses because it was a crime scene. But what they then did is they took them into their home and would not allow them to leave, although they wanted to leave, even though they could do so through an area that was not a crime scene. The plaintiffs eventually filed an excessive force claim, but they additionally asserted a claim of unlawful detention. Fortunately, in that case, we had the benefit of the qualified immunity standard, which had not yet been determined in the 10th Circuit, that what the length of a witness detention and a non-consensual detention was. And the 10th Circuit addressed that and explained that the detention of a potential witness to a crime must satisfy the Fourth Amendment's reasonable requirement, just like anything else. And they gave us guidance. And so now we no longer have the argument that the qualified immunity argument that it was not clearly established, because it has been clearly established in the 10th Circuit. So the reasonableness is that courts are going to balance the gravity of the public concerns served by the seizure, the degree to which the seizure advances the public interest, and the severity of the interference with individual liberty. So what we look at what some of those possible interests are. Obtaining information, of course, about what occurred. And it is so important to get that information before people have had an opportunity to talk with one another or think about claims. So we want to do that at the earliest possible time. But in that case, the court concluded that a 90-minute detention of a witness to a shooting was not reasonable. Now, there are no clear and bright lines that, again, it's a case-by-case analysis, but you can bet that plaintiffs asserting Fourth Amendment unlawful detention claims are going to look to Walker and that 90-minute detention. So what we need to do is we need to if you need to call out the reinforcements, additional people from jurisdictions, and have them come and interview those people as soon as possible. Get that done and do it in a way that if they start to say that, or it appears that they want to leave, that it's clear that we comply with that, or at least get them on recording that they are there voluntarily. So exigencies are a circumstance that could enable us to detain them longer than that 90-minute period, but we do have that test now established that it is no longer sufficient to do that. Another interest that that is really important is securing the crime scene. The court addressed that in Walker, and they said that detaining witnesses was different from excluding them. So they did not agree, that they concluded that the officers were entitled to qualified immunity in that case, but that there was a constitutional violation nevertheless, because the officers were keeping the witnesses within the crime scene area instead of keeping people out to protect against evidence contamination and destruction. So where they really ended was saying that the detention of non-suspects initially present on the scene in the interest of officer safety should not ordinarily exceed the scope or duration of the suspects directly targeted by the Terry stop itself. So I think the takeaway from that really is it's either consensual or a Terry stop. The reasonable suspicion, we can detain them long enough to obtain witness information from them, and really beyond that, it gets into that fuzzy gray area of the Terry stop, and then it turns into, did you have reasonable suspicion or was it consensual? So we want to make sure that witnesses are not put in a police car, when they want to leave, and held there, or taken to the police station and questioned when they want to leave. We can avoid some real risks in that area. Any questions about that or interaction?
Just a question on exigencies. What would be an example of an exigency that would necessitate extending that time frame?
That's a really good question, Jason. One that we've had in an actual case where we were able to differentiate Walker and get out on summary judgment was a case where a family member called 911, and there was it was domestic violence. And so when the officers occurred, they were of course the shooting occurred, and then there was a father there who was part of the domestic incident, and the officers didn't know whether that father who was there had been part of the initial domestic violence crime or not. And so the judge ruled that was a different sort of situation where officers needed to take a little more time to sort out what the father's involvement really was there. So that could be an exigency. I'm sure there could be others, and when you think of the exigent circumstances, you think of the immediacy of the need, medical aid, danger to the public. Do we know if that person is armed and dangerous when it's been this police shooting? So those could be examples.
Great. We had a follow-up that kind of goes along that line. How would you apply this to those individuals that are not identified as just a witness? However, it is not established that they are a suspect yet, but may be.
That's a very good question, and that goes to that example that I just gave, is that there may be additional time to be able to sort that out and interview them. What it's really important to do is then in the police report that is done is for the officer then to go back to that reasonable suspicion analysis that we just talked about, and why the officer needed to detain that person or had a right to detain that person longer than someone who is just merely a witness.
So that report is just that critical piece of information that will help us to justify all of this.
Yes, absolutely. All right, let's move on to another thing that we've been learning about. Going through all these shootings, I went and became Force Science certified almost 2 years ago. And the Force Science Institute has been instrumental in helping officers, not just in officer shootings, but any sort of very quick stressful encounter. And what we've been learning from Force Science research and analysis is that officers have perception errors that occur in stressful situations that are both physiological and cognitive, that, in other words, that they really don't have any control over. So one of the things that Force Science did was they recreated some shooting scenarios to address how this happened and measured certain things, what officers were seeing, their reaction times, what their perception was, and it was very interesting to find out what they learned. They learned, of course, what we've known all along, that officers will get tunnel vision. You know, I had a case once where an officer shot and he said he could see the inside of the barrel of the gun, the grooves inside the barrel of the gun. And that would be an example of the tunnel vision. There's also loss of depth perception, hearing distortion. Interestingly, of course, there's time distortion, which really doesn't surprise a lot of us. If anyone's been in a car accident, time can either move more quickly or more slowly. And then there's also memory distortion. The stress that it puts on someone can have an effect on what the officer is able to recall. And so one of the things that we learn from that is how we address those factors in the criminal investigations and IAs. One of the problems that can be caused is that investigators ask for details on these very subjects, on things such as distance, placement of the officer and where the subject was in the direction of the subjects, things such as how many shots. And it can be really problematic because the officers may have perceived something that was very different from what the evidence or independent witnesses actually saw because of these issues with tunnel vision and hearing distortion, the loss of depth perception. And so they can make mistakes. And one of the problems is then that creates inconsistencies between what the officer is saying, what witnesses are saying, and physical evidence. And that is where we get problems with the public thinking that the officer is making things up when he or she is not, that it really is a perception issue. And so it's important that we educate ourselves on how those things occur and are very careful from the investigator side how those questions are asked, and from the officer giving a statement how those answers are given. And one of the things that I think my partners and others that practice in this area of the law are discussing is whether it is even a good idea for the officer to give a statement any longer in these investigations. I know that is monumental. I know that's a very controversial statement, but there are some real problematic issues that have occurred as a result of that, not only in the criminal context, but later on in the civil context as well, because really what it is, from a civil standpoint, if we're looking at that, it's a deposition that it's both discoverable and can be admissible for impeachment in a civil action. And so it really acts as a deposition where you don't have your civil counsel there. You don't know what the issues are that you need to even be prepared for. And so it's something that we're taking a look at and we need to examine. And there are several factors that go into that. And we'll have to address those issues as we go through them, but it's something that we need to think about. Any questions or issues about that?
We don't have any right now.
Okay, let's move on then to the IAs. So not only in shootings, but any type of use of force or where a complaint is lodged by a person, an IA is often conducted. And it's really important to remember that those IAs The findings of those IAs and the written reports are discoverable in civil actions, and they may even and can't be admissible at trial. So we want to remember that really multiple interviews can lead to inconsistent statements. If an interview is given, what we want to avoid doing, if an interview is given in the criminal investigation, we want to ensure that in the subsequent IA that the same questions are not asked. If there's follow-up that is needed, more specifics on the information, that's another matter. And I've been involved in a shooting where I was involved early on and before this took place, and we worked through the process very well together with the investigator. And what we're doing is we're not trying to hide anything. We're not trying to gloss over anything. I mean, the IA needs to be conducted, and it needs to be done, and the right thing needs to happen. But what we can do is avoid some of those pitfalls and pratfalls that can lead to these problems, such as those inconsistent statements. So if an additional interview is conducted, it's important for the officer not to ask questions that have been already asked in the prior interview that can lead to those inconsistent statements, but really to focus in on whatever follow-through is necessary and additional questions that were not asked that relate to what the scope of the IA is. And I cannot stress enough how important that scope is. The scope of an IA investigation is limited and should be limited to whether there is a policy violation. It is not the time that we use to teach, counsel, or criticize our officers for things that they have done in the past, things that we're worried about in the future. And you might be surprised at how often we see those things happen. Really, it's not the time to, it really should be limited to whether policy is violated in that instance, in that one encounter or not. It's not the time to editorialize either on a policy violation about, if there's been a prior policy violation and we've told this officer before that he or she cannot do these things. That is not what this IA is about. That is something for an employment determination. The IA should be limited to whether there's a policy violation in this instance or not. And we don't want to, again, bring in prior policy violations, discipline, or issues. Keep the scope limited, keep it to the facts, and leave the counseling moments for another day if those are important. And again, consult with civil counsel before doing those. The IA should be done, as I said, and it should be done right in the way with law enforcement standards. But there are things that we can help avoid, such as, and you want to do it early on, and especially before anything is put in writing, so that we can reach the right conclusion, but do it in the most in the least invasive way for the officer and for the city or the county or the state, whatever the employing entity it is. And make sure then finally to include civil counsel on drafts to help and work with civil counsel on drafts so that any of those drafts will not become discoverable but are protected by the attorney-client privilege. Any questions or issues about that?
Yeah, a couple of questions there. Just as far as including civil counsel, when you do a draft, should that be labeled as attorney-client privilege, or is it just because it's a draft and it's copied to counsel? Is there anything specifically we need to do to protect that?
I think the mere fact that it is sent to counsel, for advice and counsel on that should be enough, but it's never a bad idea to include those magic words, attorney-client communication, on there as well. So it's always better to err on the side of safety of including those terms.
Okay. Now we had a question on here. Is this discoverable due to Brady Giglio?
it's not, the Brady-Giglio really applies in the criminal context. This is a civil matter, and the reason, now there are exceptions when it becomes discoverable. The reason it's discoverable is when there is an employing entity is also named in the lawsuit, and that's called a Monell claim. And in order to prove a Monell claim, a plaintiff has to prove that the employing entity had a policy, pattern, or practice of permitting similar constitutional violations or allowing conduct to occur that should have led them to know that this conduct was going to occur. And the way that they do that is through prior instances of alleged misconduct. And where do those come from? They come from IA investigations. We have tried over the years to get judges not to allow that in, but it is a losing battle. It's a waste of money. It burns credibility with the judge, and it's just, I've never had it where the judge has not allowed it. Now, there are certain things that may not be discoverable, such as medical issues or, you know, very private things that might come into play. And also, I'm very strict about what types of IAs I will produce. I object vociferously to producing, even when I do produce them, but when I do, will only produce and make clear that I'm only producing the type of the conduct that is alleged, such as if it's an excessive force case, or even if it's, say, or even broader, a shooting case, any shootings or some allegations of excessive force, those kinds of things, but not sexual harassment, things like that. So that is the reason that they are discoverable, but there are some things we can do to limit that scope. And it's important to remember, too, that just because they're discoverable doesn't mean they're admissible, but there's no guarantee that they're not. And that's one of the things you do not want to have in front of a jury, is this editorialization or criticism on these policy violations in front of a jury.
Great, thank you.
Okay, moving to the next subject is department debriefings. This is a hard one because, again, it goes to we want to learn from the past. We want to know what it is, where we can improve. But if there is a possibility that a civil rights case is going to be filed, again, these are discoverable and they can be admissible. And one of the problems is that now not only are they discoverable and possibly admissible, but now we've debriefed the entire department and we've got witnesses to what is being said, and we've got comments by other officers, and maybe we have an officer who doesn't feel that what one officer did was right. But you have that officer maybe recorded or not, you've got other witnesses in the room that officer said these things. And now the plaintiffs learn about that and they call them in to be a witness at trial. It's very troubling. You know, and it's hard because, again, our officers in a department are affected. Not only, you know, is the officer or officers involved in a shooting affected, all of the officers are facing the same scrutiny. And so they want to know what happened. They have a vested interest, and it's hard not to do these to help them to know what the facts are. You know, and historically we have used them as a tool for improvement, but I have to again reiterate that I counsel against them at this point because they are likely discoverable in a civil action. And it's important to note that that is true even if counsel is present. The attorney-client relationship does not protect against everything. It only extends as far as the attorney is giving counsel or advice as to how to proceed, receiving information from a client as to how what to do or how to proceed. It does not apply to reiterations of what occurred. Those are factual and they are not. And that is where we can get into trouble with these debriefing. They can be used against the department and the officer, both for inconsistent statements or to support the lack of a pattern policy or practice. As I mentioned, They could be another officer could be called in as an expert in the case to provide an opinion on whether that conduct was appropriate or not. So that's where it creates additional witnesses. One of the things that if a debrief is really important that could occur is we can fashion it in a way, if it's done through counsel, as advice as to how to respond and in a certain situation without bringing up the particular instance of the case, but something as a risk prevention issue like we're doing here today. And that's one of the ways that we, again, it's still not going to accomplish the exact thing and let officers know everything that happened, but at least it can help that way. Any questions on that debriefing issue?
Let's see. We have a couple of questions on internal affairs. Let me just check. Going back to the IA issue. Sorry, we've got a couple there. Let's see. Under what circumstances should we include civil counsel or not in our IAs?
I think it's you can feel certain cases that are likely to end up in civil litigation. I mean, if take a look at the complaint as it comes in from the person, and if it has the telltale signs, I think it's important. I would always, look to the city attorneys or the county attorneys. They can be helpful without having to go to outside counsel. But if it looks like it's a case that is going to end up in litigation, then I think you do want to involve them. It's not much work that has to be done, really. It's a quick call that says, here's what the issues are. Here's what has been done. How do we best go about doing this? And then having counsel take a look at a draft and a policy. Of course, the civil counsel will want to take a look at the policy because the IA is about, is there a policy of violation, and what the conclusion is. And we can help guide and direct on some language that can be helpful, and it doesn't require a whole lot of time and expense to do that.
Okay. Another question that we had, prior violations of similar policy or prior discipline for similar policy violations are often considered in determining discipline. It adds background so we can determine if progressive discipline is being utilized or even applicable. Why not include?
I have seen that. That is the general practice. What I think I am advocating, and again, this is from a risk management standpoint. I can't tell you how to run your departments as from a law enforcement standpoint. From a risk management standpoint, my counsel is not to include those in that. And maybe there's a separate arena that you use than at looking at the employment determination. Then you bring up, so you complete the IA on that issue, and was there a policy violation? Yes or no. And then there's a separate phase that deals with the employment action. And then you can take a look at each prior IA and say, we had this occasion and the officer didn't do that. We provided counseling, and and there was another similar subsequent violation, and we gave a reprimand, and then we're still having the same problem, and this is not going to be fixed. We recommend, the termination. So it can be addressed from the employment standpoint, but not in that particular investigation, if that makes any sense.
Yeah, that's great. Another question on debriefings. Debriefings are critical for many different reasons. For example, officer stress, PTSD, or learning from mistakes. Would you recommend a department only debrief certain issues?
When I'm talking about debriefings, I'm really talking about the department debriefing all officers on what has occurred and what happened. So you're right. It is important for those. If you're dealing with the PTSD and the stress issues, my recommendation would be to have the officer talk with a mental health counselor on that kind of an issue. But for just sort of really what I mean about debriefings is something is going over what happened in a certain incident and telling the entire department about it, and then having an open discussion about how to improve it or not. I think it can be accomplished in different ways. We can look at how we do those improvements with, you know, with a training lieutenant perhaps, and include counsel on that so then it becomes protected. And then we have counsel help provide forward risk management training. And still that can be sticky, because if someone gets a hold of that and they say, well, after this you counseled this, but we have a better opportunity to exclude it as a subsequent remedial measure than we would if we're bringing in all of the facts and just reciting what occurred.
All right, great. There's another one. Would you recommend a separate document from the IA on previous policy violations? Would this still be discoverable? For example, if it was called a considerations document or something like that.
And maybe I'm not understanding as well as I possibly could what really the scope of an IA should be. My understanding is that really the scope of an IA should be whether an officer violated policy in this specific instance, and nothing more. And it's really basically, here's what happened, here's what the policy said, and the conclusion is the officer violated policy or not for these reasons. Really, to me, that's what the scope of an IA is or should be. The other, looking at prior instances, goes to employment issues and how to handle that. And I understand they have been meshed together a lot historically, but as things are changing and we're seeing more of these civil rights actions, it may be time to take a look and separate those out and do it differently.
Okay. One other question we'll get on. How about a debriefing with officers involved only?
That I think is appropriate and can occur, but a counsel needs to be present. You can have civil counsel there because it's something that is done in preparation or anticipation of a potential claim, and the attorney would be giving, listening to what is occurring for the purpose of giving advice and counsel from a legal standpoint, and that is a way that those could occur. So that's a very good point and a very good question.
Great. Okay, that's it.
Okay. The next one is really public relations, and it's something that you were not trained to do as part of the law enforcement community, and I can assure you I was not trained to do it in law school, but it is something that is critical to what we do now, and it is one of those things that we have to embrace it. Now, by embrace, I don't mean enjoy. I don't mean you know, that we want to have to do it, but it is something that we face and that we do have to address. You know, the public is no longer satisfied with us coming out and saying we don't have any comment. This is under investigation. Now, that doesn't mean that we provide all the facts, and we don't want to ever compromise an investigation, but certainly raw details can be provided. And we can let the press know that because there is an ongoing investigation, we don't have all the facts at this time. We're providing what we can as it's unfolding, and there may be information that we are not providing because it could compromise the investigation. And so strangely enough, have found that the media, when you talk to them and at least give them a little bit and let them know that that's what's occurring, has been a lot more favorable in helping to put that message out to the public for us. They have faced a lot of criticism as well in the last year for not presenting officers' sides appropriately, and so they are a little more willing to reach out to us and to listen to what we say. I don't expect that we get the same time or coverage that the sensational story gets, but certainly we do want to maintain those relationships with the media because they are the ones really who help us to then educate the public and be able to maintain that balance of public trust versus the law enforcement needs of investigating and accomplishing our jobs. So, you know, I've been fortunate to work with some public relations specialists in the last year to help learn how to reach those balances. And as we've had to comment with the press, you know, we've debated back and forth between the police departments about what is appropriate to provide and the public relations specialists about what the media, you know, really might be willing to print and how we achieve that balance. And that's a working relationship that we have together. And it, you know, you'll see maybe a short comment come out or in an interview, but there was a great deal of effort that went into balancing those competing interests before those statements are made. And another thing that I think is really crucial that sometimes we forget, and it doesn't apply just in public relations, but it applies to our officers maybe who are on leave pending investigations, is to communicate with them. These are their lives. These are their livelihoods. It is horrible for them to have to learn about something in the newspaper. So if anytime we have information that we provide, that we do so to them before that information is released to the media, and to give them a heads up, send them a text, let them know that that's coming. And again, this will be an opportunity for us to educate the public and build trust. We're close to being out of time, but there's one more issue I want to go over really quickly that we're seeing. And it's very basic and elementary, but it's something I think we need to go over with our officers. And we've had several instances where we've had officers fail to maintain the chain of custody, where they have maybe left evidence in places other than immediately checking it into evidence. They may have been secured. It may have been in a lockbox in a trunk or in a glove compartment locked, but that is not sufficient. It leads to claims of spoliation, you know, inappropriate. It's just not what we're trained to do. And then they don't document each transfer from each person, and we need to ensure that that's done. And the effects of that can be really difficult. They can result in criminal charges being dismissed, civil liability for constitutional violations, and officers' job security, but really most importantly, the public trust. So what we want to do is make sure that you have a policy on chain of custody, that we do training on it, a 5-minute, you know, before once every couple months or something, just reminding officers what they're supposed to do, and then ensure that the officers are complying. There's just that one more slide to go through, and that is that sometimes we have cases where an officer might be legally justified in doing something, but it appears heavy-handed to a jury. And there are a couple of examples from cases that I have read about or been involved with. You know, they were all resulted in valid arrests, but I had one in particular in federal court where the judge expressed concern over it during pretrial conference. They can lead to settlements or offers of judgments or civil liability. So remember, it's not just what is legally right, but really that public trust in how we do things. That's the last set of information that I have. Is there anything else? Those are just those points we discussed. That any other questions that you have right now that I can answer?
Yeah, question on chain of custody. Would that documentation be done through the police report or a separate document to really track that? How would that best be done?
It's best for each entity to come up with what the policy is that fits their department and gives them the best opportunity to document that and ensure that it is done. Some have forms that are filled out, you know, with evidence, and you start not just with the evidence, but it's taped to the front, you know, and it shows each time. Some people just write on the actual envelope itself. There's not a one-size-fits-all, and I think it's important to talk with other jurisdictions and see what has worked for them, and why it's worked for them, why something hasn't worked for them, and to come up with something that then is not only feasible, but also enforceable.
Okay, great. Just looking here, we've got some thanks for the great presentation. And it looks like that's the majority of the questions asking about if the information will be available. We did record the session, and if that's all right with Heather, we'll post that up on our website so it's available for those who couldn't attend or want to review that. Let's see. I would like to see more on IA investigations in the future, so some suggestions of additional topics, and you know, with Heather's approval, you know, I think this could be a regular thing. If folks out there have a concern or a question that they'd like more information on, we can probably facilitate that. And then lots of thanks from folks.
Thank you all. I really appreciate it. Keep up the great work, and know that we are here. The Trust is here. Snow Christensen and Martin is here, and I'm personally here if you ever have any questions or needs. Thank you very much.
Thank you so much. This has been great information, and we appreciate Heather and her partnership with the Trust and all of our members out there to provide this information. And from all the comments, I can see that everybody else really appreciates it as well. Thanks so much. We're dead on 1 hour. That's great. Good work. You did better than I did on my last one. Thanks so much, folks. I appreciate that, and appreciate all of your efforts out there to keep us safe and provide order. And I know it's some difficult times, but we really appreciate your efforts in staying on top of this. So thanks so much. Have a safe day. Okay, we'll wrap it up.